Right, welcome to the Bindmans meeting, seminar, employment forum. We've been doing these on a quarterly basis, and it's good to have you here. And the way we tend to work when we are back in the pre-times, when we could actually meet each other, was we would have basically a group of people together. And the point is not really for me to lecture you, it's to raise questions as we go through. And we'll try and replicate that as best we can in this situation. So if you do have any questions, do feel free to pop it in a chat, and either I will see it or somebody in the marketing team who are assisting with this will let me know, and then we can deal with it as and when. The subject that we've decided to talk about today is protected conversations, settlement agreements, and more. And this came from a suggestion from the CIPD, for whom I do quite a few seminars. And obviously it's in part based on the fact that we appear to be heading towards another recession. And whilst redundancy, which is a topic we discussed last time, and I believe our seminar from that is still available as a recording if you wish to watch me pontificating on that, do feel free to search it out. But following on from redundancy is the issue of settlement agreements and how those are raised, some of the risks associated with them, and really how to discuss potentially quite sensitive issues in a workplace environment. And that's where protected conversations comes in. We do have some notes which I'll circulate after this, or marketing will circulate after this, but I'm not going to go through them line by line anyway, so you're not missing out by not having them to hand. They're really an aid for me, and hopefully they'll be useful for you in the future as a reference. But protected conversations are, I'm afraid, one of those many things that make me feel old. It used to be the case, as some of you may be aware, that the raising something on a without prejudice basis in the absence of an existing dispute could lead to potential complaints of constructive dismissal, which is a form of unfair dismissal. And when what is, I suppose, now the current Conservative government came in, one of the things they wanted to do was to make it easier for employers to have what could otherwise be potentially sensitive discussions. And some of you may be aware, this goes back to cases a few years ago of employees who raised concerns about the way that settlement agreements were discussed. There's a particular case where a lady returned from maternity leave and was invited to attend a meeting and was told, without prejudice, we don't believe you have a future here, and was offered a settlement agreement. Now, in that situation, there was no existing dispute, and the tribunal, and I think the EAT, the Employment Appeal Tribunal, subsequently found that it was a constructive dismissal, a breach of contract, entitling her to resign because it went to the absolute heart of her trust and confidence in her employer. So that was one of the reasons that the government decided many years ago now, 7 years or so, to make it possible to have what are called pre-termination negotiations, which have largely been described as protected conversations, which is a concept that has come from other jurisdictions. And the point of a protected conversation, a pre-termination negotiation, is it allows employers to bring up the possibility of a settlement agreement and the employee's potential departure where there is no existing dispute, because that's what the without prejudice rule applies to. If there's an existing dispute, then one party or the other can raise on a without prejudice basis the possibility of a settlement agreement, for example, or more to the point, concede things in without prejudice discussions that might otherwise potentially come back to haunt them if the case were to go to tribunal. And the point about without prejudice is that it keeps things essentially off the table, and a party cannot rely on something said during without prejudice discussions in the future. So it's part of public policy to allow conversations to take place that might otherwise lead to, I suppose, concessions that would prove damaging in court or tribunal. So we now have, and have since July 2013, protected discussions, pre-termination negotiations. And that theoretically allows employers to raise, even in the absence of a dispute, the possibility of a settlement agreement and an employee's departure. Now, there are some principles behind that. It's not an open-ended rule. It was introduced in what's called Section 111A of the Employment Rights Act. Sometimes people refer to them as Section 111A discussions. And what they do is they protect from admissibility the very fact of pre-termination discussions, not just the details. And the Section 111A(2) of the Employment Rights Act describes pre-termination negotiations as any offer made or discussions held before the termination of the employment in question with a view to it being terminated on terms agreed between the employer and the employee. And there are obviously quite a few points in that. And there was a case from 2014 where an employer fell foul of this, and it's probably quite illustrative, yes, that's the word, and useful for employers to be aware of, because this is one of the examples of where it goes wrong. There's the case of Crespigny and Information Security Forum. And in this case, the CEO of the company was invited into a meeting. And during the meeting, he was asked by the chairman whether he had considered resigning from his employment. He said that he hadn't, and was immediately told that he had lost the confidence of his staff, and the chairman wanted to end his employment in a constructive way. And that he was then told he would no longer have a job by the following Monday, 1 or 2 working days later. Now, in this particular case, the tribunal found that the discussions were not pre-termination negotiations under Section 111A, because there was no settlement offer attached to it, and it was essentially just a threat towards the employee. And that really comes back to the principle, one of the fundamental principles of pre-termination negotiations. It has to be with a view to reaching an agreement. So frequently what we tend to suggest is that an employer makes it very clear at the outset, and we would suggest following this up in writing, that there is an offer on the table. It doesn't have to be set out in black and white absolutely, although having a settlement agreement to hand is possibly helpful. But the basic point is to invite an employee to consider the possibility of entering into a settlement agreement, under which ordinarily their employment will come to an end, and it would be on these particular terms. So that would be, by and large, their notice pay, for example, or some ex gratia sum, or some other benefit that will assist them in entering into the settlement agreement. It's important when entering into pre-termination negotiations, one, to be able to pronounce it, but more importantly, to demonstrate that you have not behaved inappropriately or in a way that is what's described as unambiguous impropriety. And what that means is that, by and large, where an employee feels that they are being bullied or intimidated into accepting a settlement, that's unlikely to have the benefit of the protection from the Section 111A. There's no particular guidance in legislation as to exactly what improper behaviour is, but the ACAS Code on Settlement Agreements has come up with some suggestions, and they are essentially what you would imagine. Some of the examples ACAS have come up with are all forms of harassment, bullying and intimidation, which is obviously pretty clear. They list it, but hopefully they shouldn't have to, but they also include physical assault and the threat of physical assault, forms of victimization, discrimination because of a protected characteristic. So, for example, age, sex, race, disability, sexual orientation, and largely putting undue pressure on an employee or a party to consider the offer. And one of the main points there is not giving reasonable time to consider the offer. We would ordinarily say at least 10 working days between the offer and the deadline for accepting it or not. And it's also important in any offer to make it clear that if the employee opts not to choose it, so if you're proposing that they leave via a settlement agreement, but they decide they do not wish to do that, that their refusal will not have a negative impact on your decisions on how to proceed. What frequently happens is that they crop up in capability or disciplinary matters where, particularly for an employer, they feel that it's an open and shut case, and they get the sense from the employee that they also perceive it to be a fairly clear gone conclusion. And it's usually best phrased as, we have some concerns about, for example, your behaviour or your performance, and we feel we may have to take further steps, such as going down a formal disciplinary route or a formal capability route. But we have not decided to take those steps yet. And one of the options is departure via a settlement agreement. If you choose not to accept it, then it will not have an impact on how we proceed. So it's really about making, one of the things we talk about frequently in these sessions is fairness. And it's fundamental in this sort of situation that the employer, and it is usually the employer who raises potential termination discussions, although not always, but it's important that the parties behave in a fair way, because if you are intimidating or you bully a party, then it's unlikely to do you any favours in the future. So that is one of the principles behind protected negotiations, or protected conversations rather. And one of the key things, of course, is leading towards entering into a settlement agreement. Now, I believe that many of the people who have joined us today are largely HR professionals who I presume are quite well versed in dealing with settlement agreements, but it's probably quite useful to go through some of the things to be included in a settlement agreement and how to negotiate them in broad terms. I'm obviously not going to go through them in a great deal of detail, but assuming that you are in a position to actually have a discussion about a settlement agreement, so either there is an existing dispute and it has cropped up, that there are alternatives to dismissal or alternatives to pursuing a disciplinary matter, or, as I say, through a protected disclosure, protected conversation. A protected disclosure is an entirely separate matter, and that's in relation to whistleblowing. But protected negotiations, if you were to bring up a settlement agreement in that situation, then you're actually able to have a back and forth. Now, one of the main things that settlement agreements tend to deal with is the termination of an employee's employment. And when we're advising employers, one of the things we have to consider is, I suppose, the first thing is the strength of both parties' positions, because if the employer has behaved poorly and is sufficiently aware of their behaviour to know that they are at risk of, for example, a tribunal claim, then it may well be that what's on the table is more generous than would otherwise be the case. There are cases, and I've seen them, in fact, even today. I have received a settlement agreement for a client, under which they were offered no more than they would be entitled to under an ordinary termination. So ordinarily, an employee who has less than 2 years service does not have protection from unfair dismissal. If they have been employed for 2 years, then they qualify for protection from unfair dismissal, in which case, if they are to be dismissed, they're likely to be entitled to their notice pay, which is either contractual or statutory. Statutory is 1 week. 1 week's notice for each year of service, up to a maximum of 12 weeks. Contractual notice pay can be more generous than the statutory, but it cannot be less. If someone has been employed for more than 2 years, and I'll come on to another exception in a second, then they may have a claim for unfair dismissal, in which case it's up to the employer really to consider whether they need to be a little bit more generous in the termination proposals. And mainly that's about an ex gratia sum, usually. Up to £30,000 of an ex gratia payment can be paid tax-free. Payments in lieu of notice used to be paid tax-free, but in 2018, HM Revenue and Customs changed that. So as a general rule, notice pay is taxable. Anything over £30,000 of an ex gratia sum would also be taxable. But the consideration for the employer will be, how long is an employee likely to be out of work? What do you feel that the risks or their inclination is towards bringing a tribunal claim? And if there are a lot of grievances, for example, or the position is very acrimonious, that may give you a feeling that the employee wishes to take further action. At the moment, the employment tribunal system is on its knees. Clearly, during the COVID lockdown, tribunal cases did not get heard in tribunals, which meant that some of them were dealt with remotely, but there is still a massive backlog. And obviously, as we are heading, unfortunately, potentially into another recession, there are likely to be further unfair dismissal claims being brought now, and the claims are also going to rise. So we are possibly looking at tribunal claims not being dealt with until possibly 2021, 2022 already. And that's just to hear the merits hearing. If the claim is successful, that would be listed usually for a cost hearing to determine how much, or sorry, not cost, for a compensation hearing to determine how much compensation the successful claimant may be awarded, and that could be another year away. So we could be looking, 2 or 3 years down the line at the very least before a claim that's lodged today gets heard. Now, there are obviously issues about access to justice in that. That's not really for today's subject, but it does potentially have a bearing on how an employer will consider what to offer an employee, because it may well be that an employee will consider a lower settlement sum today on the basis that they will be certain to get it within however long is agreed under the settlement agreement. It could be a couple of weeks, could be a month, rather than putting it to the test and taking it all the way to tribunal, which, as I say, can cost an enormous amount of money, £10,000, £15,000. Both parties bear their own costs in tribunal, and it probably won't be dealt with for a very long time either. So those are factors that need to be borne in mind. One of the other exceptions to the qualification period for protection from unfair dismissal is where there is potential discrimination. There is no qualifying period for bringing a claim of discrimination on the basis of a protected characteristic. And I briefly went through a few of those earlier, but it's the usual age, sex, nationality, sexual orientation. If a claimant is able to argue or wishes to argue that he or she has been subjected to a detriment because of a protected characteristic, then they could be employed for less than 2 years, or not even employed at all, if their claim is that they have been prevented from applying for a job. So that is another factor. I'm afraid a fairly a rule of thumb that employees tend to believe that the values of their claims are significantly higher than they really are, and it is, as an employer, quite a frustrating thing, because as employment lawyers we try to advise both our clients, our claimant clients, and our employer clients on what is reasonable. But frequently you hear stories about an employee who has heard of a case where somebody has received millions and millions of pounds, and they expect that that is what they're going to be entitled to, and they will not accept a penny less than that in a settlement agreement. And realistically, that is unlikely ever to be the case. Employment tribunal awards are not significant as a general rule. They can be, there are obviously exceptions, but by and large, compensation in tribunal is divided into, well, 2 or 3 main categories. The first one is a basic award, which is for unfair dismissal, and that is the same calculation as a redundancy payment. So that's based on the employee's age, their length of service, and their salary, which is capped at £500 and something a week at the moment. It goes up every year. Then there is the compensatory award, and usually that is the main source of compensation. If an employee is only bringing a claim for unfair dismissal, so if there's no discrimination element to it, then their award is going to be capped at 60-something thousand or a year's salary, whichever is the lower, I believe. The employee has a duty to try and mitigate their losses, which means that they cannot just lodge a tribunal claim, sit back and wait for masses of compensation to come in. A tribunal will always look for evidence that an employee has been trying to find work. And obviously in difficult financial situations, that is not always going to be easy. But as long as an employee is able to demonstrate that they have not taken it for granted and have done their best to try and find work, so that's usually finding evidence of job applications, CVs filled, discussions had, interviews held, things like that, then that is a good evidence of attempts to mitigate loss. The flip side of that is that if an employee is able to mitigate their loss, then their losses will probably be capped at the length of time between dismissal and when they get another job. If their new job is on less pay than their old job, then there is a continuing balance of loss, but it reduces and reduces, and the tribunal will probably be reasonably strict about limiting the amount of compensation. I mention all of this because these are considerations that need to be had when weighing up what to offer an employee in the event of entering into a settlement agreement. Some employers are very generous because for them it is saving a lot of time, management cost in dealing with potential disputes. They know that they just pay out X amount of money in a settlement agreement, the matter will be done and dusted. And the key point about a settlement agreement is that by signing it, an employee waives their rights to bring any claims against their usually former employer. Now, that is obviously quite a good benefit to an employer because it means that they are able to draw an absolute line in the sand after an employee's dismissal or departure, and they know that they're not going to face potential repercussions in the future. For the employee, they know that they're going to get a certain amount of money. Usually there'll be a reference. References these days tend to be fairly factual, as I'm sure most of you who deal with HR are familiar, which means that it will discuss not somebody's age, that would be age discrimination, don't do that, but it would be their job title, their length of service. Some employees put in some assessment of the quality of their employees in a reference. By and large, we tend to advise against that, simply because it is not really expected these days. It's the old joke, you'll be lucky to get this person to work for you. For some employees, they expect to have a massively glowing reference, but there is a good argument to be said that if the next employer down the line gets a suspiciously glowing reference from their former employer, it might tend to suggest that there has been some negotiations and probably a settlement agreement. I mentioned earlier, and some of the attendees may have missed it because they have subsequently joined. If you do have any questions, do please put them into the chat, and we'll come to them as we go through. I'm happy to try and deal with things as we go, or we can wrap them up at the end. I mentioned settlement agreements. There are obviously certain legal formalities. There is no set prescribed agreement, although they do tend to be becoming fairly formulaic these days, which is probably a good thing because it saves too many arguments about contents. One of the main things is that an employee has to get independent legal advice on the terms. And the reason for that is that they are potentially waiving valuable claims by signing a settlement agreement. And as a matter of public policy and in fact of statute, they cannot waive those rights unless they have been independently legally advised. And that's to stop unscrupulous employers saying to a departing employee, just sign this piece of paper, would you? And then they find some time down the line that they've given up their rights to claim unfair dismissal or discrimination. There is no obligation on employers to make a contribution to legal fees, although as a general rule, most employers do. I did this seminar last week for HR professionals elsewhere, and there was a great range of contributions from £250 plus VAT up to, I think, £1,500 plus VAT. Obviously, a settlement agreement will take a certain amount of time to go through between the solicitor and the employee, and there is an argument to be said that it is better for the employee not to have to incur their own fees in getting advice on it. The point is that the employer benefits by the employee getting the correct advice because it will not be a binding agreement if they have not obtained legal advice. There are many things that can be included in settlement agreements. I've briefly sort of touched on compensation. Notice pay is usually a basic one. An ex gratia sum in relation to compensation is another one. And I've talked about how compensation is calculated. Quite a few employees struggle with the fact that if they are successful in finding other work, then their losses are crystallised and potentially even quite small. And the number of times I've had employee clients complaining that it seems very unfair that they've got another job and for that reason they do not have a great deal of compensation is beyond measure. The point really about this is that it goes back to the fundamentals of how tribunals were set up. They were originally, when they were established in, I think, the 1970s, intended to be a reasonably informal way of dealing with internal workplace disputes. It was never originally intended that they would be quasi-courts, which is what they've become now. When I was young, we used to have employment chairmen and chairwomen, but now they are employment judges, and frequently you will find barristers representing clients, and it's become a lot more formal in the way it's proceeded. And obviously cost is inevitably going to be an issue for both parties, which again is another reason for considering settlement agreements. There are employers for whom settlement agreements are their first port of call, and I would always caution to be a little bit wary about establishing yourself as the sort of employer who will always settle a dispute, because time and again you will find that where that has become known amongst the employees and settlement agreements are confidential and the terms of them are confidential, which usually means that everybody knows the contents within about 5 minutes. But theoretically, they are meant to be confidential and you're not supposed to discuss them. But it will largely become known that an employer at the first line of trouble will throw money at the problem. I've had clients in the past who have that policy and then inevitably choose to change that policy on a claim that is potentially problematic for them. But nevertheless, I would advise against one size fitting all, and do have a consideration about where you are and the risks before you throw money at the problem. The worst situation to be in, and I'm afraid I've come across it on a number of occasions, is for an employer to give a departing employee their contractual notice pay and then give them what would otherwise be an ex gratia payment, but not to record it in a settlement agreement because they are being generous. I have absolutely nothing against an employer being generous, but if you are, as an employer, going to give an employee more money than they are entitled to, you may as well get the benefit of having the protection of a settlement agreement to know that you're not going to face problems in the future. I've dealt with employer clients on a number of occasions where they have been kind to their departing employees and given them money, and I'm afraid they have used that money to get legal advice and subsequently sued their former employer. So it's important when you are going to be more generous that you get a benefit from it. I think that's the main thing I would say. I think last time I did this seminar, and as I mentioned, it should be somewhere to watch if you have the stomach for it. We discussed redundancy, and redundancy is quite a common situation in which settlement agreements are crop up, and the main reason for that is that whilst there is a statutory minimum payment, again it's notice pay. If an employee has been employed for more than 2 years, then a statutory redundancy pay, which is, I mentioned earlier, is the same calculation as a basic award. Then employers often add a little bit on top because it's deemed to be, well, as it correctly is, not the employee's fault, and it may sweeten the deal and save a lot more time and effort, which might otherwise be an argument. And then that would be through a settlement agreement. Now, when to raise that is an interesting point. I would advise going through the formal consultation process if you're going through a redundancy. So that will be the usual notification or warning, putting people at risk that there may be redundancies, and putting individuals at risk that their roles may be redundant, and then the consultation process. And I think it's reasonable during the consultation process to say, we have not yet made up our minds, but if we do make you redundant, we would propose it to be on these terms, and that would be notice pay, redundancy pay, potentially an ex gratia sum, potentially a reference. One of the other advantages of settlement agreements is that you are able to be more creative in what you can offer. If a claim were to go to tribunal and costs were awarded, for example, or compensation is awarded, that is all that can be agreed. In a settlement agreement, you can offer financial compensation, but you can also offer non-financial consideration for entering into the agreement. And that can take all sorts of forms, and it's important to keep an open mind, I think, when entering into these sorts of discussions. One of the things, obviously, is references. Other things that people are offered are the opportunity to keep, for example, a phone or a laptop. There are tax issues relating to that, but it may be a benefit to the employee, and particularly given write-offs, it may not be quite so much of a problem for an employer. Some employers offer outplacement support. I've heard mixed things about how useful that is, but that can be worth considering. But also think about other things that you may wish to offer. I'm talking here about a settlement agreement, but there is another form of agreement which is called a COT3. COT3, which is usually a 1 or 2 page agreement, which is a form of settlement agreement, which is negotiated through ACAS. And if an employee were to bring a claim in tribunal, ordinarily we'd say that an employee has 3 months less a day in which to do that. But the main thing they have to do within that 3 months less a day is to contact ACAS to commence compulsory early conciliation. And that brings ACAS on board, theoretically. In practice, I'm afraid ACAS are very overloaded as well. But what they can do is they can have a month, and potentially that can be extended by another 2 weeks, in which to explore the possibility of settlement between the parties. And this again was brought in by the government in about 2012, 2014. And the point of that is to try and minimise the number of claims going to tribunal, because if ACAS are able to reach an agreement between the parties, then it can knock it on the head. We always used to say that about 50% of claims settle before they go to tribunal. That was a few years ago. I'm not quite sure what the figure is now, but nevertheless, that can still be a consideration. Settling doesn't necessarily mean that an employee is paid money. An employee may discover or come to the conclusion that they do not have a valuable claim anyway, in which case they may enter into a drop hands agreement, in which they agree not to pursue their claim in return for their employer agreeing not to pursue costs in tribunal. Costs in tribunal are a bit of a grey area. As a general rule, they are not awarded. A tribunal does have the power to award costs, where, for example, one party or the other has behaved particularly badly, but it is very much the exception rather than the rule. If you enter into litigation, you will very frequently see without prejudice correspondence marked without prejudice save as to costs, and cost threats and cost warnings going back and forth. It does happen, but it's certainly the exception. But it is a consideration, and it may be a valuable element to enter into an agreement. So I mentioned a COT3 agreement. They will usually be limited to the issues in dispute, and they can continue right up to the door of tribunal. Obviously, the further along the tribunal process you get, the greater the cost you have incurred on both sides, and maybe the amount of any settlement pot can be significantly reduced. But it does at the very least crystallise a position, and it resolves for both parties what we always call litigation risk, which essentially is that you do not know how the judge will be feeling on the day of the hearing. He or she may have had a bad night, or may just not like that particular type of employee or that particular type of employer. And whilst in my experience, employment judges are always do their best to be absolutely fair, they are, after all, still human and may have their own issues. So litigation risk means that no matter how strong a case you may think you have, it could still go wrong when you get to tribunal. And in many cases, it may well be worth considering settlement rather than fighting it. But the weaker your position is or appears, then by and large, the larger the amount of money you as an employer are probably going to have to pay out. Again, does anyone have any questions as we go through? I'm going to take a gulp of water before I proceed. So one of the things that crops up quite frequently, and I've been doing this job for about 16 years as a qualified solicitor, one of the things that is frequently asked is about enforcing agreements. Now, in all of that time, I've known of one situation where an employee has needed to enforce a COT3 agreement, and that's where an employer had agreed to pay compensation, but within a certain amount of time, but did not do so. Similarly, a settlement agreement is a contract. It is without prejudice whilst it is being negotiated, which means that the parties cannot rely on anything in it. They cannot, for example, take it to court as evidence of a concession from one side or the other. Once it is signed, however, it becomes what is known as an open document. And that means that either party can enforce it by suing on it. Usually that would be if an employer refuses to pay what they have agreed to pay, in which case they would be in breach of contract and the employee could sue them in the small claims court or the fast track, whichever is the most appropriate court, for enforcement of that agreement. The other side also happens. There are usually confidentiality provisions in a settlement agreement. There is obviously confidentiality of confidential information belonging to the employer, and that will by and large remain confidential no matter what is written in a contract. The other thing that is often in a settlement agreement is an agreement not to disparage either party. So an employer agrees to use its reasonable endeavours not to make derogatory comments about the employee, and vice versa. An employer's obligation is always slightly different because an employer cannot realistically dictate what every single member of its staff does or says. So the wording is, will use their reasonable endeavours to ensure that its officers and employees shall not make derogatory comments, things like that. Whereas the employee is contracting on behalf of themselves, so they can say that I will not make derogatory comments. So that is usually an agreement that is in there. Post-termination restrictions are also issues that can be included in settlement agreements. Whilst it is no longer the case that if there is no contractual right to pay in lieu of notice, that the compensation would be tax-free, it is still the case that if there is no contractual right to pay in lieu of notice, but an employer pays in lieu of notice, then they have breached the original contract. So that would be the employment contract. And that would mean that they would probably struggle to try and enforce any post-termination restrictions. Post-termination restrictions are terms in a contract that are expressed to survive the termination of employment, and they are probably a subject for another day. But in principle, what they do is they would say that for example, 6 months after the end of employment, an employee will not poach staff, use their contacts to take the clients from their former employer. Post-termination restrictions are, on the face of it, void because they are in restraint of trade, and as a matter of public policy, they are not enforceable. They are permitted, however, where they are no wider than is necessary to protect legitimate business interests. So what that means is that if an employer wants to, for example, say, for 15 years from the end of your employment, you will not deal with any of our clients, that is, I have no hesitation in saying, not going to be enforceable. But if they have a more reasonable restriction, and it does vary depending on the seniority of the employee in question, the more senior an employee is, then as a rough rule of thumb, the longer a restriction is likely to be that will be enforceable, probably up to about 12 months. Over and above that, probably a bit more of a grey area, and I certainly would not advise it. But one of the other things with restricted covenants is whether the employer actually wishes to enforce them. There will clearly be cases where that is very important, and the example I always give, because for some reason I'm a child of the 80s, that's probably where I go to, but for example, if someone has the information for how the Coca-Cola secret formula, that is a sort of restriction that is quite serious and has a potential to have a really significant impact on the business, and that would be enforceable. Where it's something more trivial, the realistic consideration for the employer is, what is the loss? Where have you suffered? Because whilst there is maybe a theoretical breach, any court would nevertheless look at what the loss would be. And if there is no financial loss, then they are probably not going to be that interested in it. And the same comes with settlement agreements. An employee may breach the contract in terms of confidentiality, but as an employee, you have to have a realistic consideration of, do you want to have that fight? It may well be that the sensible thing is to threaten action but not do anything more about it, or even consider taking it a few steps further. There will clearly be cases where a breach of a confidentiality provision or a restriction in a settlement agreement will be so serious that it should be enforced. But again, you need to have a consideration of really what the losses are when you get to that. I did have a thought which flitted through my head and then flitted out again, but it may well come back to me. I've mentioned in the handout, which will be circulated after this, a few of the resources that are quite useful. The ACAS code is one of them. ACAS produces quite a lot of very useful documentation, which I would recommend people in the HR profession familiarise themselves with. Obviously, there's the ACAS code on disciplinary and grievance procedures, but they also produce documents on settlement agreements, which are worth having a look at. And also there's a guide to settlement discussions, and I've put links to both of those in the handouts. The other consideration, I've mentioned timing about ACAS and getting ACAS involved. I suppose I should quickly say that if you are an employer and ACAS calls you because an employee has, or an ex-employee has intimated that they may wish to take legal action against you, I would urge you to engage with ACAS at the very least to get an idea of what it is that the employee is arguing. It may be that it's an entirely unmeritorious complaint, but the very least that you can do is to get a genuine idea of what the risks are, because if it is a serious case that you were not entirely on top of when they left, that is your opportunity to rectify things. It's the opportunity to reach a settlement, or at the very least try and get a bit more information which may be useful to protect yourself if it does proceed to litigation, because that will be your opportunity to find out the details and then go and do the investigation, the research, get all the pieces together in case you need to defend that case in court. So that's a useful thing to bear in mind. There are, I've mentioned in the notes, quite a few cases that have related to without prejudice discussions. I would not advise getting too bogged down in it, but as a general rule, if you are having without prejudice discussions, please make sure that any correspondence or any phone discussions are clearly marked or notified as being without prejudice. Tribunals deal with this fairly routinely, but if there is an argument that either side has waived privilege, then it can have the impact of opening everything in discussion to court scrutiny. By and large, I don't think tribunals particularly like looking at these things, and they do recognise that where there is a dispute and people have been negotiating, that is a good thing, and it's probably likely to be protected by the without prejudice rule. But it's good practice just to make sure that your negotiations are marked without prejudice. If you are discussing settlement agreements, then you would mark it without prejudice, subject to contract, and the settlement agreement itself is the contract. I mentioned a little while back about the situation where employees are sometimes presented with settlement agreements that don't contain more than their contractual entitlement. And in situations like that, when I'm advising employees, I have had cause to say, well, what are you getting that you would not otherwise get? Because, for example, if it's a redundancy, then an employee is, provided they've got more than 2 years service, going to be entitled to their notice pay and the statutory redundancy pay. I've seen cases where employers have offered settlement agreements that contain only that, and they have tried to argue that that is good consideration. But from the other side, why would an employee agree to waive their rights to bring claims, potentially more onerous restrictions, if they're not getting more than they would get anyway? I don't really see by and large that there is a reason to do that. I had an HR professional last week who said that his clients did that as a matter of course, and that it was good because his employer clients got the waiver, which is absolutely right. But what is the benefit to the employee? So by and large, I would always say give an employee more than they are entitled to otherwise, because otherwise there's no reason for them to enter into the agreement. And you may have gone down the route of entering into negotiations and preparing draft settlement agreements for nothing, because there's no reason that they would agree to waive their rights for something that you should pay them anyway. Timing is another consideration, and I've had claimant clients who have said to me, I had one many years ago who was a lecturer in law, interestingly, who said he'd received a settlement agreement 2 or 3 months earlier and thought he might sit on it for another 3 or 4 months just to show his employer a lesson. And I had to explain that if he did that, then he would have no potential claims to waive anyway, because once that deadline has passed, it will be very hard, not impossible, but very hard to argue that the deadline for bringing a claim should be extended. So that's another consideration, and that's something really for both sides to bear in mind. The other thing that people talk about sometimes is publicity, and obviously it may be beneficial to the employer to avoid publicity by making sure that its employees are restricted from discussing the terms and existence of settlement agreements in public, and that's absolutely fine. What I haven't, excuse me, what I haven't touched on particularly in this is things that cannot be waived in settlement agreements, and that's probably just the useful thing to finish up on. As a matter of public policy, it is not possible to contract out. Settlement agreements used to be called compromise agreements, some of you may remember, and that was, I always thought, a much better name for them, because an employee would be compromising their claims or compromising their right to bring claims. Anyway, they are now called settlement agreements. And oh, I forgot where I was going with that. I'm sure it will come back to me. The benefit of settlement agreements shouldn't be, yes, things that are excluded, excuse me. What an employer is not able to get an employee to waive is their rights under the Public Interest Disclosure Act, what we call whistleblowing. And that's a matter of public policy. And you may remember a few years ago, it was in the news quite a bit, because I think it was the Telegraph wanted to publish, I think it may have been a government body, and I'm not going to guess more than that, but they wanted to publish information arguing that it was in the public interest. The Public Interest Disclosure Act protects people who are legitimately blowing the whistle on causes of public concern, and that's usually criminal activity, breaches of health and safety, attempts to cover up criminal activity, and things like that. Because of the sensitivities involved in whistleblowing, as a piece of legislation, it came in after the Bobel disaster, where people were aware of the problems, and I think it's the Holland Free Enterprise, or the Spirit of Free Enterprise, which was a ferry that sank in the English Channel, I want to say in the early 90s. I certainly remember it quite vividly. But the point was, in situations like that, it turned out that employees were aware of the risks, but were too worried about repercussions to raise those concerns. And because the implication of breaching those rights is so important, it is a matter of public policy that whistleblowing is not something that an employer can stop an employee from doing. And most settlement agreements will contain wording making it very clear that whistleblowing is specifically excluded. I'm afraid that quite often it's not drafted in the most clear way, and usually refers to public interest disclosure rather than whistleblowing, which more people, I would imagine, understand. But nevertheless, it's important to bear that in mind. The other thing that cannot be waived is TUPE rights, so transfer of undertaking, protection of employment rights. And that is potentially problematic, because there will be situations where employees who have transferred from one organisation to another may be happy to enter into a settlement agreement to depart in return for an ex gratia sum, for example. At the moment, that is not something that an employer can safely waive. They can enter into settlement agreements, but they run the risk that at some point down the line, the employer may argue, I waived these rights, it's turned out I cannot waive those rights, I now wish to bring my claims. So that is another consideration that cannot be waived. Most settlement agreements will also state in them that there are three things that an employee is not waiving. It will be the right to enforce the agreement. So once it is an open document, an employee will not be prevented from enforcing that agreement, and that really stands to reason. It will also usually say that an employee is not prohibited from raising a claim in relation to personal injury of which they are not currently aware. Settlement agreements can be used to waive personal injury claims. It's not their main purpose, but it does happen, particularly where there are arguments about, for example, stress discrimination, disability discrimination. And if the employee is aware of it at the time that they enter into the agreement, that can be a valid waiver of those rights. You cannot waive things that you're not aware of at the time, and that is prohibited, usually is made expressly clear in the agreement. The other thing that is usually made very clear that you cannot waive in a settlement agreement are accrued pension rights. And the reason for that are twofold. One, it's a matter of public policy to preserve people's pensions. And two, pensions are usually held by the trustees of the pension fund, who are usually not a party to the agreement anyway. So those rights remain, and that's usually something for HR in conjunction with payroll often to make sure that the employee is aware of. And obviously those, they can go off and do whatever they wish with those retirement pots, so their pension pots. So those are things that are usually kept out. I've mentioned things that can be included, and that can include things that are non-financial, and it's important to sort of consider what you can offer and keep an open mind. Sometimes employers have discussions with employees where they talk about the employee coming back to work for them on for example, a consultancy basis, where the employee would be self-employed. There's no particular problem in doing that, but I would advise against including it in a settlement agreement. Particularly, I would advise employers not to do that, because there is a good argument that where there is an agreement before an employee's employment has terminated, that they will come back and continue to work for you, that they remain your employee. That may be an issue if they leave and then some point later they come back to work for you as a consultant, but they are again terminated, or you decide not to renew that contract. There are situations where they could argue that their period of continuous employment has remained uninterrupted despite the apparent presence of a dismissal. So have discussions about people coming back to work before you reach a termination agreement, but we would advise against reaching any formal agreement with them before they do go. So I realise we've got about 5 minutes to wrap up, and I think I've covered most of the things I wish to discuss in relation to the settlement agreements. As I say, we'll circulate the notes in due course, but if anyone has any questions, do shout out in whatever form you feel you can, and I'll be happy to discuss things. If you have any questions that you'd rather discuss personally, my details are going to be on the form, and I'm sure you can find them certainly on our website. But otherwise, thank you very much for joining me today, and at some point, probably in January, we'll be doing another one. If there are any issues that you would like us to address, then please let us know one way or the other, and either by text or pigeon or whatever you feel is appropriate, and we will consider incorporating it, because part of the purpose of this is really to try and ensure that we address things that are of interest to you. So if there is anything you'd like us to look at, do let me know. But otherwise, I will take this opportunity to say thank you very much, and hopefully catch up sometime, and ideally in person, but I suspect not for a little while yet. But thank you very much.